Okay. Okay, I have just gotten the go-ahead, so I will officially start the program. I'm Mary-Beth Moylan. I'm the Associate Dean for Academic Affairs here at McGeorge School of Law. This is the California Initiative Review Forum. We are really excited that you are both here in person, and those of you who are watching as part of our live stream, welcome. Thank you. Thank you for taking the step to be educated voters. Thank you for taking the step to learn about the initiatives that we all have to vote for. So 2 years ago, we did an all Zoom presentation. 4 years ago, we were here in this room, and it is really good to be able to have both options here today. So thank you for being here. Some of you may have brought your ballots with you. Great. If you don't have your ballot with you, we have given you the initiatives at a glance, and I want to point out that it has a handy-dandy note page next to each initiative, so you can take some notes, think about how you're going to vote on things. We are lucky in California to have our ballots already. We have early voting here. You can mail your ballot in today, tomorrow, whenever you fill it out. You can go to drop-off locations. There's also early voting. If you want to go to a vote center and vote there, early voting starts October 29th. So 3 days from now, you could go to a vote center and vote. The nearest vote center to where we are sitting right now is the Oak Park Community Center. It's on Martin Luther King Boulevard, and it opens on October 29th. If you live or are near Curtis Park, Sierra 2 Voting Center opens on November 5th. So for finding out the closest vote center to you and the easiest place to drop your ballot off, you can just go to the Secretary of State's website. It is really an easy one to remember. It's sos.ca.gov, like help, right? sos.ca.gov. Type in your zip code. It will tell you the nearest voting center to you. So I want to encourage everyone, after you hear our presentation, after you get your questions answered, to make sure that your vote gets in there and gets counted, and check out the Secretary of State's website. Let me tell you a little bit about our plan for the evening, and then I'm going to sit down and let these amazing students share with you their reports. The California Initiative Review, which you should have got, that's the larger book. These are objective and neutral analyses of each of the statewide ballot propositions and the one referendum that we'll be voting on this November. Also included this year are City of Sacramento local measures. We've also done an analysis of each of those. So you're going to see propositions 1, 26, 27, 28, 29, 30, 31, and then local measures L, M, N, and O in the booklet and in the initiatives at a glance. The format that we're going to have today is that each of the students will come up to do the report, a summary of their report for you. We're going to go through all of them, and then we're going to do the questions and answers at the end. I suspect there will be a lot of questions for some of the initiatives and not a lot for others, so I'm going to let everybody get through their summary reports to tell you about each one of them. And, oops, here's our agenda. So we're going to go straight through by number. I want to note a couple of things. Proposition 1 is an initiative that was put on by the legislature. That's why it's Proposition 1. It's not numerically following what we had last year because the legislature put that on towards the end of the cycle. Also, Proposition 31, you'll see it's a referendum. A referendum is different than an initiative. So for this election, we have one legislatively referred initiative, that's Proposition 1. We have 5 voter-initiated propositions, those are 26 through 30, and then we have one referendum, Proposition 31. and then the local measures. So we're going to go through them in that order. I'm going to hand it over first for Proposition 1 to Yuri and Brenna.
Good afternoon, everyone. Thank you so much for being here today. My name is Yuri Katka, and I will be discussing Proposition 1 along with my colleague Brenna Hatcher. Proposition 1, it is a constitutional amendment proposed by the California Assembly, California Senate, which is also supported by Governor Gavin Newsom. This proposition, if passed, would amend the California Constitution to prohibit the state from denying or interfering with an individual's reproductive freedom, which is defined as an individual's decision on choosing or refusing to have an abortion or take contraceptives. So we'll start with the current California law. Current California law allows abortion to be performed if the fetus is not viable or the fetus is viable, but the pregnancy puts the health of the pregnant person at risk. Because of the recent changes within Supreme Court, Governor Newsom, along with a couple of the other states, have passed Assembly Bill 1666, which protects citizens from other states that are also threatened by the abortion bans. The reason we're discussing the right to contraceptives and right to abortion at the same time is because of them falling under the same legal protection, and they're both considered as fundamental rights. So let's look at how we got to the point that we got today. Initially, we look at Griswold versus Connecticut, where the court established the right to privacy with an intimate relationship and held that a married person has a right to privacy regarding decisions about childbearing. Later on, in a different case, court actually extended that right to unmarried couple. Now, most of us are very familiar with Roe v. Wade, which is a more prominent case in terms of developing abortion laws, because it said banning abortion was an infringement of a constitutional right to privacy, where court also included contraceptives, hence making abortion a federal law from that time until it got overturned. Now, the next case we looked at was Planned Parenthood versus Casey, which basically extended the test that was used under Roe v. Wade and then give it a different test, which really doesn't need to go into, we don't really go into detail because it's just a difference between the tests. The very recent case, Dobbs versus Jackson, Women's Health, it actually overturned Roe v. Wade because the court decided that the Constitution does not discuss the right to an abortion because it does not mention abortion. And because the protection for abortion was only found within case law, this ruling took away the federal protection for abortion and gave the right to states to decide, however, if they would like to protect or prohibit abortion within their own state. Now, with that being said, I'm going to pass it on to my classmate, Brenna, who will be discussing the rest of the issues.
Thank you, Yuri, and hi, everyone. My name is Brenna. So as Yuri was saying with Dobbs, even though the states now have the right to regulate abortion, there are a few areas of law where there might be constitutional issues, either with how the way that Proposition 1 is drafted and or because abortion and contraceptives encompass other areas of law, and so it can be challenged in the courts. So going on with the drafting of Proposition 1, the states say the state cannot deny or interfere with an individual's reproductive freedom. Now, there is no definition for what deny or interfere means. Now, intuitively, deny means like any sort of regulation stopping is prohibiting, or if Proposition 1 were to pass, that would be prohibited. But interfere has a more permissive meaning, and so that definition could be argued in a court system if Prop 1 were to pass. Now, moving on to interjurisdictional issues. Now, because abortion and contraceptive care encompasses other areas of law, there's different levels of law where it could be challenged and or interpreted in other areas. And if you look in the policy pamphlet, you'll look through preemption, where it talks about what happens when Proposition 1 could conflict with other areas of law in federal law. Like, for example, like right now, it just got ruled this past week in Congress, but They're right now codifying whether or not you have a right to contraceptive care, so this wouldn't be as prevalent of an issue. But for example, for abortion with AB 1666, with a state ban allowing abortion for out-of-state residents, this could come into conflict with another state if that out-of-state resident moves back to that state where abortion is criminalized. Now moving on to proponents and opponents of Proposition 1. People who would vote yes for Proposition 1 would say that this enshrines the right to Proposition 1, it enshrines the right to reproductive freedom, and it would protect people's rights to access to abortion and to reproductive care. Now, currently, California law recognizes reproductive choice, but this would provide a more permanent protection for citizens. Now, advocates for abortion rights who would vote no on Proposition 1 would argue that some of these constitutional issues with the drafting of the legislation would not protect reproductive freedom. And then moving on to advocates against abortion rights. So again, advocates would say that life starts at conception, so therefore an abortion would be killing a child, so therefore there's no such thing as a right to reproductive freedom. Some of the ads that are being put out for voting no on Proposition 1 are being pushed by the Catholic Church and then some evangelical churches. Meanwhile, the state legislature, as Dean Moylan explained, is being positioned by Governor Newsom and the state legislature. And we'll be taking questions at the end. Thank you.
Good evening, everyone, and thank you for joining us. I am Jara, and with my colleague Elizabeth, we'll be going over Proposition 26, which is the California Sports Wagering Regulatory and Unlawful Gambling Enforcement Act. I will briefly be discussing the history and the existing law, and then the changes that Proposition 26 is proposing, and then Elizabeth will go over the proponents and the opponents' arguments. For a more in-depth analysis on the issues, please refer to our work in the California Initiative Review. So really quick, looking back at the history, it was in a Supreme Court case in 1987, California versus Cabazon, in which the Supreme Court recognized the inherent right of Indian tribes to allow gaming on their lands. The following year, in 1988, is when Congress passed the Indian Gaming Regulatory Act, which set up the structure and the framework for states and tribes to negotiate the scope and regulations for which games could be allowed at tribal casinos. There still were some prohibitions. Games played with dice, such as roulette, and also sports wagering were still prohibited. Sports wagering has been prohibited at the federal level when Congress passed the Professional and Amateur Sports Protection Act in 1992, also known as PAPSA. In 2018, in another Supreme Court case, Murphy v. NCAA, New Jersey argued that PAPSA was actually unconstitutional and was a violation of the anti-commandeering doctrine. The Supreme Court agreed with New Jersey and then overturned PAPSA. More than 31 states have since legalized sports wagering. All right, and now where California currently is. Through the years, California has allowed wagering on sports, on horse races, and has also allowed various levels of gaming at tribal casinos through tribal state compacts. There are currently 64 tribal state compacts engaging in the operation of 67 tribal casinos in the state of California. There are governing commissions that set up the regulations and enforce the gambling in the state of California. Now, there are three major changes that Proposition 26 is proposing. Sorry, I keep getting confused with my other colleagues' proposition. So the first one would amend the California State Constitution to allow a wider variety and a broader scope of games to be negotiated into tribal state compacts, such as games played with dice, like roulette. The second and biggest change that Proposition 26 is proposing would allow in-person sports wagering. This would be allowed on any federal tribal lands through tribal state compacts and also on 4 approved racetracks. This would be, once again, as I said, in person. It would not be allowed at kiosks or at terminals, and the participants must be 21 years of age. At the 4 racetracks, there would be a 10% tax on the sports wagering profits. 15% would go to the Department of Health, 15% to the Bureau of Gambling Control, and then the remaining 70% would go to the state's general fund. Now, sports wagering would be allowed on any professional and amateur sports and athletic event, on almost all college sports and events. However, it would be prohibited to wager on any game in which a California college is participating, and there would still be a prohibition on wagering on any high school games. And the third change that Proposition 26 would be proposing would be to allow, in some instances, for private citizens and entities to file civil suits against unlawful gambling 90 days after the Attorney General's office if they refuse to file a suit. And now I'll turn it over to Elizabeth for the proponents and opponents' arguments.
Thank you, Jara. Hi, everyone. My name is Elizabeth. And so amongst proponents of Proposition 26, there are about several indigenous tribes that are supporting this proposition: the California Nations Indian Gaming Association, chapters on the NAACP, and more. They argue that this proposition will bolster the revenue source produced by tribal gaming, further promoting tribal sovereignty and self-reliance. They argue that tribal casinos currently provide Californians with over 150,000 jobs and $12.4 billion in wages. Tribal casinos currently generate $26.9 billion for the state economy and contribute nearly $1.2 billion in state taxes and revenues, and $489 million to local governments annually. Additionally, proponents point out that 30 of the states that have legalized sports wagering have had tax revenue increases. 22 of the states have revenues in the millions of dollars, and one being New York at the highest at $274.1 million as of 2022. Last, proponents argue that Prop 26 will shut down illegal gaming by limiting participation to adults and protecting against underage gambling by requiring individuals to be physically present to place bets with ID and age verifications. Now, opponents. I'm just realizing the slide did not change. So Proposition 26 is opposed by California licensed card clubs, animal welfare organizations, and more. Opponents are concerned that this proposition will increase gambling addictions and that will impact the resources in local jurisdictions. They argue that this proposition will increase frivolous lawsuits, forcing card clubs competitors to close, and that closure would then lead to loss of millions in revenue and over thousands of jobs. The revenue loss would disproportionately hurt communities of color, leaving us with less funding for social programs. Lastly, opponents argue that horse racing has been declining in popularity over the past years. Several animal rights advocacy organizations fear that allowing sports wagering at the 4 racetracks will again attempt to revitalize the dying industry. Lastly, this initiative, alongside Proposition 27, fail. There is already another statewide ballot initiative that is currently pending signature verification by Secretary of State's office. The new initiative is being led by the San Manuel Band of Mission Indians that would allow both in-person and online sports wagering. And if approved, this will be on the 2024 election.
All right, thank you, Elizabeth. So in conclusion, a yes vote supports this ballot initiative, which would legalize sports wagering at the approved racetracks and on tribal state lands. It would also tax the racetracks at 10% of the sports wagering profits. It would also broaden the scope of Class 3 games, which could be negotiated into tribal state compacts, specifically games played with dice like roulette. And it would also permit private citizens to bring lawsuits in some situations where the Attorney General's office has declined to do so. A no vote opposes this ballot initiative and continues to prohibit sports wagering, roulette, and games played with dice in California. Thank you.
It looks like there's some animations. That's kind of, there you go. Yes, both of us. Alrighty, so hello everybody. My name is Ismail. I'm going to be talking about Proposition 27, the Legalized Sports Betting and Revenue for Homelessness Prevention Fund Initiative. So I want to start my presentation about briefly talking about the existing law behind Prop 27. Secondly, I want to move on to the proposed law from Prop 27. Then I want to talk about some of the challenges I think Prop 27 will face if it passes. And then I'll conclude with a summary of the proponents and opponents' arguments on Prop 27. Okay, so first, like I said, I want to just briefly talk about the existing law because the last group in Proposition 26 covers a lot of it. Now, I only want to supplement and complement that by saying of the 31 states that permit sports betting, 21 of those states have permitted online sports betting. So if Proposition 27 passes, California would join that second list of the states that permit it online. So with that being said, I want to move on to the proposed law. This proposition is a constitutional amendment and a statute enactment. The constitutional amendment is pretty short and straightforward. It just puts into our Constitution that online sports betting is permitted in accordance with the statute. Now, the statute is the bulk of this 63-page initiative, and it's a new chapter, the Online Sports Betting Control Act. And this chapter does a number of things. First, once again, it reiterates that online sports betting is permitted in California for the gaming tribes, for online sports betting platforms with an operating agreement with the gaming tribe, and thirdly, a qualified gaming entity with a market access agreement with the gaming tribe. The second big thing that Proposition 27 does is that it imposes a 10% tax on the profits of online sports betting. Now, I do purposely say profits because online sports betting platforms are able to make deductions from the revenues before they impose the tax on their profits. So those 10% of the profits will go into a new trust fund, and the monies in that trust fund will be allocated 85% to a homelessness account that will be used to address the homelessness crisis in California. And then 15% will go into a tribal development account, which will provide funds for the smaller non-gaming tribes. So this act also has a number of prohibitions. First, it prohibits anyone under the age of 21 from placing sports bets online. And it requires that the sports betting platforms use reasonable measures to ensure that no one under the age of 21 is placing sports bets. This act also requires that any online sports betting platform be licensed to offer online sports betting. The initial licensing fee is $100 million or $10 million, and it will be required to be renewed every 5 years for $10 million or $1 million, respectively. So in order to enforce this new act, Proposition 27 creates a new division, the Division of Online Sports Betting Control. The director of this division is appointed by the Attorney General and works at his leisure. But the division also has a 17-member committee with appointments from all over, some from the governor, the attorney general, the Senate pro tem, and other state officials. So this division has the power to enforce this act, and they can impose penalties, $15,000 up to $15,000 for one violation, or up to $100,000 for multiple violations, or they can choose to suspend a license. So to get this division up and running, it's going to require a $30 million loan from the general fund that will be repaid with the profits. That's one of the deductions that online sports betting platforms can make before giving that money over to the homelessness accounts and tribal development accounts. Okay, so now I want to move on to some of the challenges I believe Proposition 27 will face if it passes. Now, there are a number of them that I highlight in my California Initiative review. For the sake of time here, I'm only going to cover one of them, but for the full discussion, please refer to that. And the one challenge I want to talk about is the conflicting measures clause. So under the California Constitution, if two initiatives on the same ballot during the same election conflict and they both pass, the one with more votes goes into law, and the one with the lesser amount of votes does not. So I want to remind you about Proposition 26, which they just talked about. That's going to permit sports betting in person only, and at tribal lands and certain racetracks. While Proposition 27 is going to permit sports betting anywhere you can go online, anywhere in California, on your phone, on your laptop. You don't have to be on tribal lands. So there is a pretty clear conflict between the two, since one would be 27 says you could do it anywhere, and 26 says you have to be on tribal lands or these certain racetracks. Despite that clear conflict, Proposition 27 has a conflicting measures clause that's kind of novel. It says that the voters, the people who vote this in, find that Proposition 27 is actually complementary to 26 and supplementary to 26. Now, I think that this is going to lead to some litigation. It's going to have to if they both pass, because the court is going to have to find out, well, what do we do with this? Do we defer to the proposition language and the people who voted it in, or are we going to defer to our own judgment? Now, in my opinion, they should defer to their own judgment. Like I said, the conflict is pretty clear, and just giving the weight to the language can lead to some bad results with propositions in the future. Okay. So like I said, there's many more challenges with ambiguities, with some constitutionality of the proposition that I discussed. But for now, I'm going to move on to the arguments from proponents and opponents. All right. So first, the proponents' arguments. Some of the proponents include some sports leagues, some state officials, and actually some of the smaller tribes. So the smaller tribes first, they support Proposition 27 because of that tribal development account, the 15% of the profits that they will be getting from the trust fund. They see some prospect in getting that money and helping develop their tribes. State officials, they support Proposition 27 because they say that Proposition 27 will be the first time in California having annual and regular funding to earmark towards solving the homelessness crisis. And then sports leagues, and of course DraftKings, FanDuel's, the ones who put most of the money behind this, they support this act because they believe that sports betting should be permitted in California, and it should be done so safely for the patrons, and that California is a big market, so that doing so would make a lot of money for them and for California. Okay, so then the opponents of this proposition include, once again, some state officials, and then most of the tribes. Most of the tribes are the people who are backing up the no on Proposition 27 front. So they argue that they're going to lose their sovereignty, and they're going to lose the prospect of all the online sports betting funds that can be used to develop their tribes. Some state officials reiterate that, saying that the tribes have been handling their sovereignty well and handling gambling well, that we shouldn't take that away from them. There's some other arguments that Proposition 27 will turn every phone into a sports gambling machine, and that children will get their hands on it. And then one last argument is that this proposition creates a division that's both costly and unnecessary because it's going to require a $30 million loan, and in California, we already have the California Gambling Commission, which regulates and enforces gambling law. So to conclude, I want to say that a yes vote supports permitting online sports betting in California for people 21 years or older. It creates a new fund and a new regulatory body in the online sports gambling. It imposes a 10% tax on online sports betting profits, and then creates a fund to disperse those taxes to solve homelessness and provide some funds for smaller tribes. A no vote means that we are just going to keep the law how it was. Online sports betting won't be permitted, and there won't be any annual funding for homelessness. And I just want to echo what the last group said. This is probably not the last time, even if both propositions don't pass. This is probably not the last time we won't see sports betting prop, because the Office of the Attorney General already has a new one on their desk combining both. So if you guys don't like those ads, sorry, they're going to keep popping up. Thank you.
Hello, my name is Alec. I'm going to be discussing Proposition 28 alongside Yuri, who you heard from in Proposition 1. Proposition 28, if passed, would provide additional funding for arts and music education in public schools. I'm going to discuss the current law, proposed law, dive into the finances because it is a little confusing. Yuri's going to wrap up finances and then discuss proponent and opponent arguments. So currently, education funding comes from a lot of sources: federal funding, state funding, local funding, and other sources such as the state lottery. Also, fun fact, any unclaimed prize money from the state lottery also goes to public education. So if you don't pick up your prize money, you're helping fund education. There are a couple of tests that the state legislature uses to determine funding, and those are detailed in the full report. Those tests come from past Propositions 98 and 111. These tests provide a minimum guarantee of funding for public education every year. This minimum guarantee can be suspended by the state legislature, but it has only been suspended twice. In 2022 to 2023 budget, the education budget overall in the state of California is $128 billion, and the Proposition 98 funding makes up about $110 billion. In the current law as it exists, this funding is not specifically earmarked for topics as this new proposed law is. So that's the current state of the law. What this proposed law would do, first and foremost, it would not create a new tax, or there would be no new tax increase. This additional funding would come from the state general fund, and I'm going to explain that on the next slide because the proposition wording is confusing. And then, once again, this funding is specifically earmarked for arts and music education. The funding also targets low-income schools, which will also be discussed. So the funding, there's a lot of numbers, and I know everyone loves math, so let's dive into it. This additional funding, the phrasing is confusing, but it provides an additional 1% funding. The 1% is determined by that minimum guarantee formula that I discussed from Proposition 98. So it's not taking 1% of the general fund overall. It's adding 1% it's calculating 1% of that minimum guarantee, and that 1% then comes from the general fund. I'll just reiterate, the 1% is based on the minimum guarantee, and then that 1% number comes from the general state fund. So that's how the overall funds are determined, and then where the state fund and where the funds will come from. So that is how the overall funds are determined from the state budget. And then the funding distribution, this is where it gets into targeting low-income schools. So 70% of the funding, the majority of the funding, will be determined by the school's enrollment in the previous fiscal year divided by the statewide enrollment in the previous year. 30% of the funding is determined based on economically disadvantaged pupils in the district, and that phrase is defined in the proposition, divided by the total statewide enrollment of economically disadvantaged students. So this targets low-income schools because the more economically disadvantaged pupils you have, the larger amount of funding in that category you're going to get. I'm going to turn it over to Yuri to finish up on funding and then go into the opponent and proponent arguments.
Thank you, Alec. So just like Alec mentioned, because let's just say I would try to make it as simple as possible, because the funding for the next fiscal year is of $110 billion, what would the 1% be of that? So $1.1 billion, and how would we use it? Well, if Proposition 28 is passed, 80% of that $1.1 billion would be used, it must be used to employ certified or classified employees to provide art education or instruction. 20% of that fund, again, 20% of that $1.1 billion, can be used for training, supplies, and materials and art education partnership programs. California Department of Education does have a waiver for a good cause shown, which is more described in the packets that you have, but they just have a waiver, and that could be requested by the principal or the person in charge at the school site. So next, we're going to be talking about proponents and opponents of Prop 28. And let me just start by saying that there won't be any tax increase, because I know most of us are kind of focused on, well, how much tax will it go up or down? But there won't be any tax increase. There are two major arguments that was made by proponents, and they've spent $9.9 million in support of Proposition 28. The first one being making sure the important programs that are traditionally receiving funding cuts if there's any budget issues. So if Proposition 28 is to pass, there won't be any funding cuts to art and music programs. They also back that up by discussing that because art and music education is actually related to improve attendance, better standardized test scores, and higher college aspirations, people should be voting yes on Proposition 28. The second argument that they made is that this proposition is crucial because it's focusing on low-income schools all over California. Now, going to the opponents who have actually spent $0 on their stand, so it's just an opinion that we've gotten without research. And what they argue is that education funding in California has reached a record high level. When they said the record high level, now the opponents are arguing taking it back to 1988 when the initial Prop 98 was passed on how to fund school programs. The second argument that opponents have is that it could potentially take away from other states' programs since the $1.1 billion is coming out of the general fund. And it might force the state to enter into a fiscal crisis, and that's one of their arguments. Again, to conclude, Prop 28 supporters or proponents have spent $9.9 million, and opponents have spent $0, so that's just opinion. So if you were to vote yes in proposition, that would mean that the state will be providing additional funding to low-income students and to make sure all the art and education program will be intact if there's any funding cuts. And if you were to vote no, that means the state will not be provide any additional fundings. We'll be more than happy to answer more questions at the end, and thank you so much.
Thank you.
Hello, everyone. My name is Christian Landaverde, and I'll be presenting with Alex Gufori on Proposition 29. Proposition 29, also known as the Protect the Lives of Dialysis Patients Act, is a statutory initiative which seeks to add regulations to kidney dialysis clinics by adding provisions to the California Health and Safety Code. Kidney dialysis is a blood cleaning treatment that's needed when a patient's or a person's kidneys fail. These provisions would add new regulations to the existing rules that govern kidney dialysis clinics. So under current law, kidney dialysis clinics are federally regulated by the Department of Health and Human Services and the Centers for Medicare and Medicaid Services. Dialysis clinics must have at minimum one board-certified medical director on staff, but the current law does not require the minimum amount of time which that staff member has to be present at the clinic. Clinics are also required to report dialysis-related infection data, which is data on infections that occur while a patient is receiving treatment, to the National Healthcare Safety Network, which is a part of the Federal Centers for Disease Control and Prevention. Finally, the California Department of Public Health is then responsible for issuing licenses to individual dialysis clinics. The proposed law would require kidney dialysis clinics to maintain at least one licensed physician, nurse practitioner, or physician assistant present on site during the clinic's operating hours. It would also require dialysis clinics to obtain approval from the California Department of Public Health before closing or substantially reducing their services. Clinics would also be required to report all dialysis-related infections data to the California Department of Public Health in quarterly reports. Also, clinics would be required to report to patients and the state of California all physician ownership of that clinic of 5% or more. And finally, this proposition would place a bar on clinics from turning away patients with government-backed insurance plans. If this proposition looks familiar, it's because Californians have seen dialysis initiatives before. In fact, in 2020, we already voted on the exact same initiative known as Proposition 23 at the time, and that was rejected by the electorate with 63% of the vote. Prior to that, Proposition 8 was introduced in 2018, and that was the limits on dialysis clinics' revenues and required funds. And what that did was it capped kidney dialysis clinics from, once they reached profits of 115% or more, the cost of care and treatment and improvements, and then those funds that were above that threshold would then be reimbursed to their patients or to the insurance provider who paid for that dialysis. That proposition was also rejected with 59% of the vote.
Thank you, Christian. My name is Alex Scafori. I'm going to be going over the supporters and opponents. So we're going to be starting off with the proponents. One of the largest proponents is the SEIU United Health Workers West. A large contribution from them, roughly around $7,900,000 has been spent. While looking at the opponents, you can see there's a larger amount of them compared to the proponents, including DaVita, Friend Issues, Medical Care, the California Taxpayer Protection Committee, California Medical Association, and the California Chamber of Commerce, which have spent significantly much more than the proponents at $86 million. Now we're going to be looking at the policy considerations. We have the yes and no on Proposition 29. We'll start off with the yes on Proposition 29. Those who vote yes claim the new staffing requirements may increase patient safety during treatment. Additionally, it would require clinics to obtain consent from the state before closing or substantially reducing services. It would also increase transparency of dialysis clinic operations, and it would also prohibit dialysis clinics from refusing care to patients due to government-backed insurance. Now, looking at the no on Proposition 29, those who vote no claim that the requirements for clinics to have a physician, nurse practitioner, or physician assistant during all treatment hours would increase the clinic's cost. Proposition 29 could increase state Medi-Cal costs as well as state, local employee, and retiree health insurance costs. Additionally, it would increase costs to the California Department of Public Health to implementing requirements. As well, clinics may decide to obtain approval from the state to close their clinics. Proposition 29 is not unfamiliar to California voters, as Christian had explained, nor is the reach for dialysis clinic reform. This proposition, like its predecessor in 2020 and there before, seeks to add staffing and training requirements as well as reporting criteria for kidney dialysis clinics across the state. The proponents of this initiative think these new requirements would improve patient care, while the opponents of the measure say the dialysis clinic currently operates under an effective method and such amendments to the health code are unnecessary. When deciding this issue, voters will determine if dialysis clinics need more regulations to provide patients quality care. If you would like to learn more regarding Proposition 29, the California Initiative Review has plenty of information in regards to not only this year's but prior year's information on it as well. Thank you.
Good evening, everyone. Thank you for being here tonight. I will be talking with you about Proposition 30, tax on income above $2 million for zero-emission vehicles and wildfire prevention initiative. First, I will discuss the initiative itself, what brought it to the ballot, and then finally some potential challenges and policy arguments for and against the initiative. Moving on to the initiative itself, as the title suggests, this will increase state income tax on income over $2 million by 1.75%. The additional revenue from these taxes will create a fund that has the goal of reducing emissions from transportation and wildfires through public investments. This fund will be split into three categories: 45% to ZEV incentives. ZEV, zero emission vehicles, sometimes those phrases are interchanged, but that would include payments to buy new vehicles, 35% to zero emission vehicle infrastructure such as charging stations, and 20% to wildfire prevention and suppression efforts. Now we must ask, how did we get here? It's important to note that California has some of the most ambitious climate change reduction goals in the world. California is known as the world leader in reducing greenhouse gas emissions, and California has created an aggressive agenda in order to reverse the impacts of climate change. Specifically, in recent years, 2 policy mandates have accelerated these goals. The first is the executive order passed in September of 2020 by Governor Gavin Newsom, which requires that by 2035, all passenger vehicles in the state of California must be zero-emission vehicles, and by 2045, the same goes for medium and heavy-duty trucks. So to be clear, this means that in 2035, you can still drive your gas-powered vehicle. However, if you were to go to a dealership to buy a new vehicle, all vehicles that are new on that lot would be zero-emission. Additionally, another policy mandate passed by the state and by the California Air Resources Board is called the Clean Mile Standard. Now, the Clean Mile Standard sets restrictions on the transportation sector, specifically on ride-share app-based companies. So think companies like Uber and Lyft. And this requires that for those companies, 90% of their vehicle miles traveled must be logged by a zero-emission vehicle by 2030. Opponents believe that the true motive behind Proposition 30 is to ease compliance for these rideshare app-based companies, but I'll get into that a little bit later. For now, I will get on to some potential challenges that Proposition 30 may face. First of all, I will talk about the Supreme Court. Recently, in West Virginia versus the Environmental Protection Agency, the United States Supreme Court relied on what's called the Major Questions Doctrine to limit the Environmental Protection Agency's power or authority to regulate emissions at existing power plants under the Clean Air Act. Now, this is important because it may present a challenge for California's own climate goals. In order to set its own emission standards here in California, ones that are more aggressive than what the federal government or the EPA has set for the nation, California has a waiver. And this waiver allows California to set its own emission goals. If litigation challenging the EPA's authority to grant California this waiver reaches the Supreme Court, the court may also rely, similarly as it did in West Virginia versus the Environmental Protection Agency, on that Major Questions Doctrine to revoke the authority that the EPA has to give California this waiver. The second issue that I'd like to talk about is rising consumer energy rates for all Californians. With more electric vehicles on the road, it's clear that there's going to be a larger strain on the electrical grid in California. Not only has the energy grid been criticized in the past for its inefficiencies, especially during high temperatures and causing public safety power shutoffs, but also the California Public Utility Commission has shown in a report that over time it's estimated that energy rates for Californians will outpace inflation and will continue to increase. This is important because in order to accommodate zero-emission vehicle technology, aggressive action will be needed to protect low-income ratepayers who are the most affected by rapid increases in consumer utility rates. I will now discuss the policy positions for and against Proposition 30. Proponents include the California Democratic Party, the California Firefighters Association, and several environmental groups and interests and more. Notably, of the over $37 million proponents have raised for Proposition 30, $35 million of that has been contributed by Lyft, the rideshare company. Proponents have 2 angles to their arguments. 1, clean air, and 2, the need for zero-emission vehicle infrastructure to meet the ambitious goals of California. First, proponents believe that action is necessary to prevent wildfires and reduce vehicle pollution because simply Californians deserve clean air. 7 of the 10 smoggiest cities in America are in California, and 1.2 million California children have been diagnosed with asthma. They also argue that climate-driven wildfires devastate Californians, destroying communities and even claiming lives. Some of us in this room know the effects and the impacts of wildfires all too well. Proposition 30 would allow more funding to create defensible space to protect more people, more homes, and more businesses. Second, with Proposition 30, zero-emission vehicles will become more affordable for all Californians. Within the first year, more than 500,000 shared public electric vehicle chargers will be implemented. And this is notable because I was talking about those goals that California has, the executive order to have zero-emission vehicles more on the road by 2035. In order to meet that goal, the Energy Commission estimates that 1.2 million shared electric vehicle charging stations will be needed, and today there are just over 79,000. So clearly, the proponents feel that this funding is needed to achieve these goals. Moving on, however, to the opponent slides. It may be surprising to some, but Governor Gavin Newsom is an opponent of Proposition 30, along with the Howard Jarvis Tax Association, the California Teachers Association, and Cal Chamber, among others. Opponents also have two angles. One, Proposition 30 is a corporate carve-out, and two, California already has some of the highest taxes in the nation. First, opponents, including Governor Newsom, feel that Proposition 30 is a corporate special interest carve-out for app-based rideshare companies like Lyft and Uber. And they must comply with that clean mile standard that I was discussing earlier, which means 90% of their miles must be logged by zero-emission vehicles by 2030. The opponents feel that these companies, by funding this proposition, they are pushing that burden from those companies onto the taxpayer. Secondly, California already has some of the highest taxes in the nation. As mentioned, this increase will increase for this tax bracket state income tax to 15.05%, and at the federal level, income at this level is taxed at 37%. Opponents argue that if proposals for cleaner air are a state priority, then it should come from existing state funds. And already the state has shown its commitment to these goals. For example, in the 2021 California budget, $10 billion was pledged over the next 5 years to increase zero-emission vehicle infrastructure and access. In conclusion, a yes vote means supporting an increase in taxes for income over $2 million to generate revenue for zero-emission vehicles, infrastructure, and wildfire prevention, and a no vote means opposing an increase, and funding for those priorities will remain the same. Thank you.
Hello again, my name is Alex Gafori, and with my colleague Christian Ladaverde, we're going to be going over Proposition 31, the flavored tobacco products ban. So before we talk about the proposed law, we're going to be talking about the current law. But Proposition 31 is a referendum on the 2020 Senate Bill 793 that would prohibit the retail sale of certain flavored tobacco products. Under the current law, Senate Bill 151, which was enacted in 2016, the purchase of tobacco products minimum legal age was raised in California, making the legal smoking and tobacco products purchasing age from 18 to 21. California has a cigarette tax of $2.87, which was enacted in 2017, while other tobacco products are taxed at 65.08% of the wholesale price. And under California Penal Code Section 308A and the Stake Act, they prohibit the sales of tobacco and tobacco paraphernalia, including electronic cigarettes, to any persons under the age of 21. Now moving on to the proposed law. Proposition 31 proponents want voters to vote no so that Senate Bill 793 will not take effect and the sale of flavored tobacco would remain legal in the state. SB 793 does not ban shisha, also known as hookah tobacco, sold and used at the store, certain cigars, or loose leaf tobacco. This proposition would define flavored tobacco products as those that have a flavor apart from the regular tobacco flavors that are out there. And additionally, it would charge a $250 penalty against stores and vending machine owners for each violation of the requirements described previously at each specific location. Now I'm going to be passing it off to Christian to discuss policy considerations and the opponents and proponents' arguments.
So policy considerations for voting yes on Proposition 31. Yes vote would uphold the contested legislation, which is Senate Bill 793, and that would make the bill operative and ban the sale of flavored tobacco products. Flavors such as menthol and combustible cigarettes, sweet and fruit flavors in e-cigarettes, oral tobacco, and little cigars are targeted to and disproportionately impact young people and minorities. Flavors and fruit e-liquids are also claimed to be responsible for the upswing in youth vaping recently. Reasons for voting no on Proposition 31. A no vote is to repeal the contested legislation, thus keeping the sale of flavored tobacco products legal in the state of California. If upheld, this could decrease the state's tobacco tax revenues, which range from tens of millions of dollars to hundreds of millions of dollars annually, and the prohibition would have a negative financial impact on small businesses who might already be operating on tight margins. The proponents' arguments, again, this is a referendum, so the proponents of Proposition 31 are the opponents of Senate Bill 793, and thus they advocate for a no vote on the referendum. The No on Prop 31 campaign is being led by Californians Against Prohibition, and they're asking for a no vote on Proposition 31, trying to repeal the legislation. The California Fuels and Convenience Alliance also opposes Senate Bill 793, stating that will have a significant impact on the state's tax revenues while failing to truly address the issues involved in teen vaping. Finally, the Vapor Technology Association also opposes Senate Bill 793, stating that any ban or limitations on the access of vapored products can directly impact consumers who are reliant upon vapor products as an alternative to combustible cigarettes, and not to mention that it might jeopardize businesses that Californians have. The opponents' arguments. The opponents of Proposition 31 are the proponents for Senate Bill 793, and they advocate for a yes vote on the referendum. The Yes on Proposition 31 campaign is led by the Committee to Protect California Kids, and they're asking for a yes vote on Proposition 31 to allow the legislation to take effect. Senate Bill 793 was sponsored and supported by the Campaign for Tobacco-Free Kids, American Lung Association California, the American Heart Association, and the American Cancer Society, Cancer Action Network, and Common Sense when the bill was introduced in the legislature. Finally, opponents also state the California African American Tobacco Control Leadership Council supports SB 793, and they note that 85% of African American adults and 94% of black youth who smoke are currently using menthol products. In summary, a yes vote on Proposition 31 would uphold Senate Bill 793 and thus enabling the ban on the sale of flavored tobacco products. A no vote on Proposition 31 would repeal the legislation and maintain the sale of flavored tobacco products legal in the state of California. Thank you.
One more to go, and it's the measures now. So that's all your statewide ballot propositions. We're going to turn to the Sacramento City measures.
Hello again and good evening. My name is Elizabeth Rocha Zuniga. Myself, my partner Jara, will be talking about the measures rather quickly, so please refer to the analysis within the booklet. So starting off with Measure L. So this measure would amend the City of Sacramento's charter to allocate an amount of its general fund revenue equivalent to 40% of the total revenue generated from the existing cannabis business operations tax that would create a Sacramento Children's Fund. There will be no tax increase to fund this new program to invest in youth services. The targeted group for this measure is those that are younger than 25 years of age. The program that the measures seeks to invest into are about mental health counseling, violence intervention programs, family support services, and more. As of now, the City of Sacramento may amend and adopt proposed budgets for youth services. This measure will change that process by requiring this allocation every year. The proponents of the measure put into perspective that 30% of the population in Sacramento are youth. And with the growing cannabis industry, proponents would like to prevent substance abuse by investing into prevention programs. They argue that the government is also responsible for the increase of youth involved in crime and that this measure would hold the government accountable. Opponents of this measure argue that this exact idea has spelled twice within the City of Sacramento, Measure Y and Measure G, for quote-unquote good reason. The opponent's main argument is that this measure is irresponsible because there is already an allocation of funds for youth services. The perspective is that this measure limits the city's council's ability to fund other programs, that the pressing concerns for the community are cleaning up the city, homelessness, climate change, and other critical priorities. So if this measure passes, they argue that the constituents' priorities will not be addressed. Another major issue is ballot box budgeting. This is because of current economic uncertainty. The opponents state that there are high inflation rates and falling incomes that should be considered before locking up this fund. A yes vote on Measure L will amend the Sacramento City Charter to include this allocation for the Sacramento's Children Fund. A no vote on Measure L will be against adding the amendment for this allocation for the Sacramento's Children Fund.
All right, Measure M, redistricting map implementation. Currently, after the census, when a new redistricting map is adopted, it goes into effect immediately. In previous years, this has led to having 2 council members in some districts, causing confusion amongst the constituents as to who is their elected official. So this measure would clarify that the new maps will go into effect at the next regular election. There are currently no opponents to this measure. So a yes vote on this measure will clarify that new maps will go into effect at the next regular election. A no vote keeps maps going into effect immediately. All right, Measure N, Sacramento Tourism and Economic Development Facilities Update of 2022. This measure amends Sacramento City Charter to update the language for allocations of the transient occupancy tax to allow for a broader scope of fund usage, specifically for economic development projects that create local jobs and improvement for the Sacramento tourist economy. Just to be clear, there is no increase in the taxes, just in the language. There are also no opponents to this measure. So a yes vote would change the language of the transient occupancy use taxes and updating it, and a no would keep the language as is.
Now Measure O, which has been on the news not only here in Sacramento, but in San Francisco and across the state because of what it is hoping to do. So this measure would add a chapter to the Sacramento City Code to address homelessness in the city of Sacramento. However, it would only be enforceable when the county and the city of Sacramento memorialize each of their roles in addressing homelessness. This measure mandates that the city manager establish a minimum number of new emergency shelter spaces based on the estimated number of people experiencing homelessness. The city manager may also identify and authorize more emergency shelter spaces if there are sufficient funds. Additionally, the measure focuses on the enforcement of the city's unlawful camping ordinances on shelter space availability, prohibits encampments, allows residents to bring action against the city for unlawful camping or storage on the city property, and limits the city's annual general fund budget obligation to $5 million. It is important to also highlight that when this measure was proposed, there were many community organizers who expressed their concern. On August 16th of 2022, advocates announced a legal action challenging the measure being on the November ballot. They argue that under Martin v. Boise, a Ninth Circuit Court decision, that this measure is in violation of the 8th Amendment of the U.S. Constitution, which protects individuals from cruel and unusual punishment. This court found that municipal ordinances that criminalize sleeping, sitting, or lying in all public spaces when no alternative sleeping space is available violates the 8th Amendment. However, within the legal action challenging the measure, Judge Chang ruled that the advocates did not show how the measure was invalid. But she also ruled that if the voters pass the measure, it may be legally challenged in the future. Both the city and the county have recently passed ordinances that banned encampments on sidewalks along critical infrastructures, such as the American River. Now, proponents argue that there are thousands of people who are currently living in unsafe and unhealthy conditions. Mayor Steinberg has stated that if this measure passes, it quote-unquote is an open door for creating a right to shelter, a right to housing, a right to mental health care. Proponents also argue that this measure will increase safety and help improve business by removing the people experiencing homelessness from certain areas. Additionally, the measure seeks to have the location of the shelters be away from schools, daycares, playgrounds, and neighboring parks. Opponents argue that this measure violates people's rights to live as they choose. They also claim that the measure's foundation is based on corporate interest, forcing the City of Sacramento to put this measure on the ballot by using their money and influence. Additionally, opponents argue that the measure is not equipped to deal with the crisis because of how urgent the issue is and because of how currently the city cannot afford to keep open the shelter spaces that we currently have. Lastly, opponents argue that the contingency between the county and the city will be an unspecified agreement that will be determined behind closed doors, not being a democratic process. A yes vote supports requiring the city to provide shelter beds and to make it a criminal offense to camp in private and public areas. A no vote opposes the requirement of the city to provide shelter and opposes making it a criminal offense to camp in private and public areas. Thank you all so much.
Okay, that's a lot for us to vote on, but we are now ready to take your questions. We're going to have microphones coming to you. If you raise your hand, we'll have people walking. As you're thinking about your questions, I forgot to say that the California Initiative Review Forum is sponsored by our Capitol Center. And thank you very much. Professor O'Neill Mullenberg is here, and she is on the live stream. So she is watching for questions on the live stream, and anyone who's watching from home who has a question can please type it in, and Professor Mullenberg will ask your question. Folks who are here, raise your hands. Yes. Here comes a microphone for you.
Thanks. Everybody did a really great job presenting this. I really appreciate it. For Prop 26, you all noted that there are no Indian tribes mentioned in the list of coalition members. When I looked online at the Vote No on Prop 26 coalition website, at the bottom it says it's sponsored by the Hawaiian Gardens Casino, California Commerce Club, and Knighted Ventures. I was wondering if you knew who they were.
Yeah, so those are card clubs, most of them down in Southern California. Yeah, you're welcome.
Other questions? Oh, we have a question down here.
This is a question about the local measures. So I noticed that a number of them are amending the local city charter. In order to accomplish the purposes of those measures, does it require a vote of the people, or are these things that the city council could do on its own?
Thank you for that question. I'm not really sure about
Yes.
that process.
The
but-
answer is yes. It requires, so in order to amend our charter, it does have to have a vote of the people. The ones, but there are, that's why they're going for the transit occupancy tax. Language is in the charter, and the census and redistricting one is in the charter. The homelessness one is an ordinance, it's a code, right? So the city code does not need a vote of the people, just the charter amendments do.
So this is the follow-up. In order to accomplish the purposes, though, is it the charter that needs to be amended, or could that also be done through a code?
I'm going to repeat the question for the people online, since you weren't speaking into your microphone that someone took away from you. So I will repeat the question, which is, could the purposes be achieved through a city code change, or do they need to be a charter amendment? And the answer is that I believe that because we have existing charter provisions about both the redistricting and about the transit occupancy tax, and what's the first one?
The Sacramento.
Oh, the children's fund, yeah, that would be, that is not required to be put in our charter. That would be in addition to the charter. So Measure L, we don't need a charter amendment to do. Measures M and N, we do. And Measure O is a city code change, not a charter change. Hopefully that helps. You're welcome. Catherine has another question. Yeah.
I have a handful of questions.
Good. Go.
Okay, for Proposition 27, I have two questions. It states that there must be commercially reasonable means taken to prevent those under whatever 21 or whatever to not gamble. I was wondering if that's defined in the initiative.
Is this thing on?
Yep.
Yeah? Okay. I couldn't help myself when I was giving the speech by holding up my air quotes because no, it's not.
Okay.
I do discuss that as being an ambiguous term.
Okay.
Because it's not defined, so I don't really know what online sports betting platforms are supposed to do to ensure that.
And then my second question is about the tribal delineation, because I think there are, you identify that the smaller non-gaming tribes support it, and then that most tribes are in opposition to it.
Mm-hmm.
So is there a did you research at all the difference between the tribes? I mean, I guess I'm wondering, tribes that are federally recognized versus tribes that are not federally recognized, and the background that has an impact in this initiative?
So they're all going to be federally recognized tribes. I think that the difference between the two, between the smaller non-gaming tribes and the ones that oppose Prop 27 is the gaming. So the no on Prop 27 is funded by mostly tribes, but they have, like, it's twofold. It's no on 27, yes on 26. So they support 26 because that means sports betting will be permitted on their tribal lands, which means, of course, that all that sports betting money is going to go to the tribe. Now, the smaller non-gaming tribes with no casinos and no gaming on their land, they couldn't care less because they would support 27 because with the new development, the tribal development account, they would at least see some of the profits from sports wagering. Now, I recall from Jera's discussion that some of the money from Proposition 26, some of that tax was going to small non-gaming tribes too. So it is a little gray area, but I think that with 15% of the 10% profits, that's probably a bigger amount for them, so they want to support 27. Thank you.
We can have some questions on this side too. We do have a microphone over here, but we'll let this side is being dominant. Go ahead.
On Prop 27, I was shocked by the licensing fee of $100 million. Would it be safe to assume then that a very, very, very small few would be able to afford such a licensing fee and thus create potentially a monopoly risk with one or two, perhaps, online gaming platforms controlling everything?
Yeah, you might want to sit down for this. So, $100 million licensing fee is for only the qualified gaming entities with the market access agreement with the gaming tribe. So that means it's the gaming entities that have a certain number of casinos or a certain number of gaming in the country. For the online sports betting platforms and gaming tribes, the fee is $10 million. So DraftKings and FanDuel, although they didn't write this, they gave themselves a lower licensing fee of $10 million. So the qualified gaming entities are going to have a harder time, and some of them have argued that the $100 million is just too high, that they're never going to be able to come into California and do that. Yeah, it is a monopoly. Gaming tribes, I'm not sure how much they're going to partake in it if Prop 27 passes, but for sure FanDuel and DraftKings will have an easier time making up that money.
We have an online question.
No, this is my
First,
personal
okay.
question. I'm just following up on 26 and 27. I know you mentioned with 26 that college sports are exempted. I'm wondering why, and if it's the same with 27. And then also my second question on this is, what's the justification for the separate agency? Why can't it be folded into the Gaming Commission to the extent that it were to pass?
You have made Jara's day. I just want to say she has been waiting for that question because she loves to talk about this.
Excellent.
Go.
Yes.
Go.
I love talking about sports in general. So it's not all college sports. So there's only a prohibition on California college sports. They say it is to protect them. However, they do not say what they're being protected from. We already have penal codes, 336 and 337, I believe it is, that prohibits there's violations if you were to bribe, manipulate, or coerce any athlete to throw a game. And so we already have structures in place to protect our athletes. And why we only need to protect California athletes, I am not sure. And then also they say that you can still wager on brackets, but they do not say how you're supposed to wager on a bracket in which a California team is participating, but you're prohibited from wagering on a California team for winning. So this is an ambiguous term that is within the drafting that I really don't think they thought through clearly. Yes, and they also, to move on one step beyond that, they do not say that it is prohibited to wager on athletic events of youth. So high school sports plus is very different from, say, elite basketball or AAU. So are you able to wager on those events? There's a lot of parents that will step into that ring and wager on those events. They're very hot topics. And that's different than high school games. So they're not very clear on exactly what and why they're prohibiting.
Thank you.
Yeah, and in my review of Proposition 27, I don't see them discuss college events as much as Proposition 26 does. I think they just kind of rely on the existing law and the general prohibition on those college events. So a lot of the same ambiguities is going to occur if Proposition 27 passes as well, because those apps, they offer sports betting on college events as well. I guess we'll have to see how that plays out.
And I think the second part of the question was for you, Ismail, about the why a separate entity to regulate gambling when we already have the Gambling Control Commission in California.
With all of those appointments.
With
for
a
all
lot of
those
appointments
people.
already, yes.
Yes.
Yeah, so I wanted to rationalize it as well. And I thought to myself, well, is the Office of Attorney General okay with this? And when I looked into it, there's just no comment. It seems to me that they think we need a separate division for online sports betting versus California Gambling Commission just handling everything else. Now, I don't get it either. I think that a $30 million loan and 17-member committee and one director for a whole new division is quite unnecessary. Yeah, I just didn't see any rationalization made by the proponents. It's just in there.
And no one is writing or thinking about that?
We are.
We are, yeah.
Yes.
We have a question up here. The other side has spoken.
This is regarding Proposition 26, and I'm a little curious about this. There's a new enforcement act that will be added, provisions to permit private citizens to bring lawsuits against illegal gaming operations in some situations where the Attorney General's office has declined to sue. I don't understand that, and I'm not sure if that's a positive or a negative. I voted yes already, and I mailed my ballot. And this is one question. I have no questions about the rest of the act, but what does that mean? Because somewhere on TV or something, frivolous came into there, like frivolous lawsuit.
Yeah, absolutely.
Can you
So thank
clarify that? Is that a negative or positive? And can you speak up, because I won't be able to hear you otherwise.
Yeah, I will speak right into the microphone. You're welcome. So whether it's a positive or a negative, that is for you to decide. How it works right now is that when the Attorney General office becomes aware of a violation of unlawful gambling, they then choose whether or not to file an action against them. So what this new amendment is proposing, or what they're adding, is that any citizen, you or I or any entity, can go into these card clubs, and if we suspect that there's unlawful gambling going on or they're playing games that are still prohibited to the state constitution, then we ourselves can take that to the Attorney General, say, hey, there is a violation. If the Attorney General office decides not to sue, after 90 days of being aware of this violation, then we ourselves can file a lawsuit against the unlawful gaming. And so the card clubs are very concerned about this because over the past few years, they have had to pay out millions of dollars in violations of their gambling licenses. Yeah.
And just to, I'm going to add one thing about that provision. So what the card rooms are saying is they are concerned about frivolous lawsuits, that they're just going to be harassed with a whole bunch of suits by private citizens. The one thing to add is we already have provisions, courts have provisions to prevent frivolous lawsuits. You can be declared a vexatious litigant if you file too many frivolous lawsuits. Attorneys can be sanctioned for filing lawsuits that don't have merit. So the idea that somehow the court system wouldn't be able to weed out the frivolous lawsuits from the merit-based lawsuits is a little specious. I'll just add that. Yes, we can hear you. Thank you.
I have a question on Proposition 30. When you talk about the clean mile standard, how is it that Lyft is trying to push the clean mile onto others? Can you explain what you mean by that?
Sure, absolutely. So for a refresher for everyone, the Clean Miles Standard was passed by the legislature in 2018 and adopted by the California Air Resources Board in 2021. And it was that measure that I was talking about where it requires app-based rideshare companies like Lyft and Uber to have 90% of their miles logged by zero-emission vehicles by 2030. And what the opponents would argue to that question specifically is that these rideshare companies should be offering incentives themselves to their drivers to help them transition to zero-emission vehicles, and that it shouldn't fall on taxpayers to pick up the weight of transitioning all Californians to zero-emission vehicles when this mandate is just on those two rideshare app-based companies themselves. I hope that answers your question.
I also have a question on Prop 30, because you talked about the energy grid and the impact on it and how we can't even really sustain our electricity usage now. So how will we be able to sustain that with an additional 500,000 energy stations for ZEVs in the future?
I think that's the question. That's the answer. There is no. Right now, I can tell you the California Public Utilities Commission is concerned about the rise on demand in the energy grid. And they've emphasized that aggressive action is needed to make sure that, especially for urban and rural areas, that a transition to a zero-emission future is also paired with an increase in reliability on our energy grid. And so that is a question that remains unanswered as how California, with what's in place now, will respond to this increased demand. And I think the answer would have to come from new legislation or new funding to increase our reliance on the energy grid.
Got a question up here, Saul.
Yeah. I have a question on Prop 29 for the required law, or the proposed law's requirement for dialysis clinics to obtain approval before closing or reducing services. Do we know which criteria would be assessed or looked at when the California Department of Public Health is considering an application to close or reduce services?
Yeah, I think the way this is written, that discretion. Yeah, I think the way that it's written, that discretion would go to the California Department of Public Health, and I would assume it would look like an adjudication, which they'll view the application and they could either rubber stamp it yes or no and provide a brief explanation as to why that is. I know that it's not just reducing services, it's substantially reducing services and closing. And I think really underlying all this is that there's two major kidney dialysis clinics that operate the majority in the state of California, and I think the goal is indirectly to regulate those. So I don't think there's direct criteria. I just think they will look at that and see if it would substantially reduce the service, or it might negatively affect the community in which this dialysis clinic is. But included in the full analysis is also a section that says how the agency can issue fines to clinics who don't comply. So I think just the way that this is written, this gives a lot of discretion to the Department of Public Health to just use the adjudication procedures that they see fit.
Again, on Proposition 29, I read through the LAO report too, and just because I got a text that said that voting for, or I forget honestly, but whatever, they said that if I voted for it, that it would close dialysis centers, and so I was like, what, why? And I was just confused, and because it's, adding care, so why does adding care mean that, or regulating care mean that we would close those centers? And you get down into like the fiscal analysis, right, and not being able to afford keeping them open. But then when you look at like Ballotpedia and see who's paid for these initiatives in the past, especially, there's like a trend of unions versus the dialysis corporations. And so it makes me wonder what this is really about, because it doesn't seem to be about patient care. Can you speak to that at all?
It was, will this close clinics? I think that was the question.
I guess ultimately my question is about like, if you could read between the lines of the unions versus the dialysis corporations, like, is there a different argument that they're having? Because it seems like they're having this sort of above board fight about patient care that keeps getting knocked down by the people in these initiatives, but it keeps coming back. So like, why do we keep having the same argument? Is it really about patient care?
I think both the proponents and the opponents say that the other side is going to essentially like hurt kidney dialysis like patients. There is cited in the full analysis is an opinion piece submitted to the San Diego Tribune by one of the opponents of Prop 29, and within that they give it as much weight as you want, but they make a brief mention about how SCIUs made attempts to unionize people in dialysis clinics. So that might be kind of the underlying battle by requiring new employment criteria. So essentially having more employees there, that might increase the chances that they might be able to unionize that workforce. So if that's maybe something that opponents have pointed out, but I think front and center is conversation that maybe having these new requirements might increase the quality of care for patients.
We have a question right down here.
On Proposition 29 also, if there's a deficit of required physicians per inhabitants in California throughout the country, on Prop 29, and there's a limited number of physicians, MDs I'm talking about, that specialize in dialysis and kidney diseases, et cetera, then where do these specialists come from?
I think that would still, it would just be supply and demand, I think, is what proponents would say. And within the initiative is it allows for the Department of Public Health to give exemptions to clinics who can't meet the hiring requirements of either one, because this specifically requires either one physician, nurse practitioner, or physician assistant, and included in that is also 6 months experience. So dialysis clinics can apply for an exemption to the state agency if they can show that they made a good faith effort to hire, and they just were unable to meet the demand, whether it's because there's no professionals in the area or whatever that may be. but they can apply for an exemption should that situation arise.
Okay, we are at 6:30. Thank you all so much for joining us. Please go vote, just one time, but do go. Okay, thank you all. Thank you all.